Good day, fellow educators. This is Miss Arjem Agum, and I will be presenting with Miss Mary Jeremy Angeles about a case digest on child abuse. This is the case between the appellant Felina Rosaldes and respondent the People of the Philippines. Case GR number 173988 was decided on October 8, 2014 with Bersamin J. as ponente. The appellant prayed for the court to review the decision and ruling of the Regional Trial Court and Court of Appeals. She also ordered to approve her as certiorari and to not convict her of child abuse. The respondent's appeal, on the other hand, is for the court to retain the ruling and decision of RTC and CA. Here are the facts of the case. The petitioner, Felina Rosaldes, was a public school teacher at Pughanan Elementary School in Lambunao, Iloilo. Michael Ryan Gonzalez, on the other hand, was 7 years old and was Mrs. Rosaldes' student at that time. One morning of February 1996, Michael hurriedly entered their classroom and accidentally bumped the knee of Mrs. Rosaldes, who was sleeping on a bamboo sofa. After that incident, Mrs. Rosaldes asked Michael to apologize, but the boy disobeyed and proceeded to his seat. Angered, Mrs. Rosaldes pinched Michael on the thigh, held him up by his armpits, and pushed him on the floor. Michael's body hit a desk, which made him unconscious. Mrs. Rosaldes then picked him up by the ears and repeatedly slammed him down on the floor. Michael cried. Mrs. Rosaldes continued with teaching as if nothing has happened. During lunch break, Michael was accompanied home by two of his classmates, Luella Loredo and Jonalyn Gonzalez, and told the incident to his mom, crying. His mother and Aunt Evangeline Gonzalez reported the incident to Barangay Captain Gonzalo La Rosa, and Barangay Captain La Rosa advised them to bring Michael to a physician to be examined. Michael's aunt and barangay councilman Ernesto Ligante have Michael checked by Dr. Teresita Castigador at the Dr. Ricardo Y. Ladrido Hospital, and they also reported the incident to the police station. In the medical certificate issued by Dr. Castigador, it read that Michael suffered the following. First, petechia and tenderness of both external ears 1 by 2 cm and 1 by 1 cm. Next, lumbar pains and tenderness at area of L3 to L4. Next, contusions at left inner thigh 1 by 1 and 1 by 1 cm. Lastly, tenderness and painful on walking, especially at the area of femoral head. Because of the physical evidences, Mrs. Rosaldes was charged with child abuse by the Iloilo City RTC. The RTC also found Mrs. Rosaldes guilty beyond reasonable doubt of violating RA 7610 Article 6, Section 10A. The court then sentenced her to an indeterminate prison term from 4 years 2 months and 1 day to 6 years and 1 day, and to pay the costs. However, Rosaldes appealed to the CA. On May 11, 2005, the CA dismissed the appeal filed and confirmed the decision rendered on June 26, 2003, criminal case number 468893, and modified her sentence from a maximum of 6 years and 1 day to a maximum of 10 years and 1 day imprisonment. During the investigation, it was found that Mrs. Rosaldes have also shown cruelty and maltreatment to two other children, Luella Loredo, Michael's classmate, and a child named Dariel Legayada.
We found three issues with their decisions and rules of law. Issue number one, Should the Supreme Court review the findings of fact by the lower courts? The answer is no. The SC believed that although it is true that the limitation of the review to errors of law admits of exemptions, none of the exemptions applies to the petitioner's present recourse. Based on the internal rules of the Supreme Court, Rule 3, Section 4, the following situations are the exceptions in which the court may review findings of fact by the lower courts, to wit, the conclusion is a finding grounded entirely on a speculation, surmise, and conjecture. The inference made is manifestly mistaken. There is grave abuse of discretion. The judgment is based on a misapprehension of facts. The findings of fact are conflicting. The collegial appellate courts went beyond the issues of the case, and their findings are contrary to the admissions of both appellant and appellee. We found three issues with their decisions and rules of law. Issue number one: should the Supreme Court review the findings of fact by the lower courts? The answer is no. The SC believed that although it is true that the limitation of the review to errors of law admits of exemptions, none of the exemptions applies to the petitioner's present recourse. Based on the internal rules of the Supreme Court, Rule 3, Section 4, the following situations are the exceptions in which the court may review findings of fact by the lower courts, to wit: A. The conclusion is a finding grounded entirely on speculation, surmise, and conjecture. B. The inference made is manifestly mistaken. C. There is grave abuse of discretion. D. The judgment is based on a misapprehension of facts. E. The findings of fact are conflicting. F. The collegial appellate courts went beyond the issues of the case, and their findings are contrary to the admission of both appellant and appellee. G. The findings of fact of the collegial appellate courts are contrary to those of the trial court. H. Said findings of fact are conclusions without citation of specific evidence on which they are based. I. The facts set forth in the petition as well as in the petitioner's main and reply briefs are not disputed by the respondents. J. The findings of fact of the collegial appellate courts are premised on the supposed evidence, but are contradicted by the evidence on record, and all other similar and exceptional cases warranting a review of the lower court's findings of fact. Issue number 2. Is the petitioner's treatment to Michael just an act of discipline as loco parentis? The answer is no. The SC pointed out that the petitioner's treatment to Michael is not act of discipline appropriate for loco parentis. According to Article 233 of the Family Code, the person exercising substitute parental authority shall have the same authority over the person of the child as the parents. In no case shall the school administrator, teacher, or individual engaged in child care, exercising special parental authority, inflict corporal punishment upon a child. Issue number 3. Is the information charging the petitioner with child abuse sufficient? The answer is yes. The SC agreed that the information charging the petitioner of child abuse is sufficient. RA 7610 Section 3 defined child abuse as the habitual or not maltreatment of a child, which could be any of this: 1. Psychological and physical abuse, neglect, cruelty, sexual abuse, and emotional maltreatment. 2. Any act by deeds or words which debases, degrades, or demeans the intrinsic worth and dignity of a child as a human being. 3. Unreasonable deprivation of his basic needs for survival, such as food and shelter. 4. Failure to immediately give medical treatment to an injured child, resulting in serious impairment of his growth and development, or in his permanent incapacity or death. Ephesians 6:4 reminds us, parents, to not provoke our children to anger, but nurture them in the discipline and instruction of God. Mrs. White also tells us in Child Guidance that God is dishonored if, like Rosaldes, we do not have true understanding of what discipline is, which makes our children confused. Later, this harsh discipline may lead to disrespect to authority as well as the law of God. May we always take care of our students and children just how God desires us to take care of them. We hope that you learned from this. Thank you and God bless.